Hello. Welcome back to my channel, Romel, Private Investigator. I'm Romel, and my company is Access Diversified Investigations. It's good to see you all. I hope all is going well, especially during these challenging times. In any event, what I'd like to discuss with you, a very important matter, is for private investigators and, let's say, those civilians, those persons who may experience someone coming to the door in a criminal matter seeking some information when you yourself are a prosecution witness. So basically what I'm going to be getting into is what you need to be mindful about speaking with prosecution witnesses. Let's get it on. In speaking with prosecution witnesses, as a private investigator in particular, you need to be very, very mindful of protecting yourself. You know what they say about the fighters? Protect yourself at all times. You got to do this. You really have to do this. So how does that whole process start? You're a private investigator, you have perhaps a homicide, and you have to speak to a prosecution witness. So approaching that witness, one of the things you need to be mindful of is you have to identify yourself to the point where the person realizes that you are there in behalf of the defendant. Doesn't mean the defendant's guilty. It doesn't mean the defendant is not guilty. It just means you're there on behalf of the defendant. And in that capacity, you will sometimes be challenged by people who know a little something about the case, not enough to make any type of decision as to whether or not the defendant committed the offense at hand, but certainly they can be a bit objectionable. So in identifying yourself, that's the first degree of protection. The second degree of protection, always carry a recording device on you. Now, recordings for the state of New York are third party. And what that means is only one party need to be aware that a recording is taking place. So keep that in mind. Getting further into the process, another thing you need to realize and take under grasp is how much information can you divulge? Look, let's make no bones about it. At the end of the day, more often than not, you have to give up some degree of information to get information from someone else. That's the society, that's the world that we live in. So the question is, how much information and what type of information can you actually reveal in your efforts to ascertain some information from the prosecution witness? And the answer is very simple. Only that information which is already out there, especially if it's something that's gotten to the news, you can make reference. Your reference should not be posed as any degree of fact. Constantly use the word "it is believed" or word "similar" when you start introducing fact or what's presumed to be fact. You're putting yourself in a very precarious situation. Now, just so that you know, when you are interviewing a prosecution witness, you can't intimidate them. It's not a good idea to badger them in any way. That can be perceived as something other than mere badgering, but something exceptionally more incriminating to you. You need to be mindful that you can't coerce the person. And so what happens is the penal law provides penalty for that type of activity. And what happens is you subject yourself to what's referred to as tampering with a witness, and that comes in varying degrees, which will take you from a misdemeanor to a felony. And trust me, it does happen. You would be surprised at some of the comments made by prosecution witnesses to the prosecutor after you have left having had an interview with that person. I have had situations where the person called the prosecutor and suggested that I said something contrary to what I said, that implied that I told them that I was a police officer, a detective, and so forth. And this brings me to another point, mind you. Another thing I always do is leave my business card. My business card clearly states that I'm a private investigator, and clearly I have nothing to do with law enforcement at all. And so I remember a situation, I'll be brief, where this very thing happened on a homicide. I had spoken with a young lady's father. He got upset. When he got upset, I decided it was time not to speak with him anymore. He called the prosecutor, made a whole lot of accusations about me. It suggested that I was intimidating him for a particular comment. Now, when the attorney I was working for got back to me and explained what had happened, I said, that's not true. I produced the tape recording that I had, the audio recording that I had of what took place. I also made note that I left my business card with the father. So the father subsequently produced the business card, so that cleared me in that respect. My attorney made mention that I recorded the conversation, and once the father got wind of that, everything changed. Protect yourself at all times. People can be, for whatever reasons, I'm not getting into the social science of it, but people can take you for a ride. You want to go north, they're going south really quick. Keep that in mind. In the actual process of your inquiry, your investigative inquiry, you want to keep certain things in mind. More likely than not, your time will not only be pressured, it will be limited. People are not going to talk, but so much. So you have to do a lot rather quickly, but you have to do it intelligently as well. Otherwise, you draw blanks. You don't get what you need. You get a lot of this, but that's about it. Cadence. Oftentimes when you hear private investigators talk about interviews, one of the things they make note of is a certain cadence. What they try to do is speak in a cadence similar to the person that they're questioning, to develop some sort of a rhythm and to sort of lead the person into their line of questioning, such when that cadence goes off, it may be the introduction to some great information and or perhaps something else for that matter. Now, you don't have time often with a prosecution witness to do that. So one of the things you want to keep in mind while speaking with a prosecution witness is to keep your focus not on the cadence, not even necessarily on the cooperation, but the questions and or information more so that you are seeking to uncover. At some point, that person will begin to pay a certain degree of attention to you. Because as you may, or at least should know, when you approach an individual in a situation like that, they're sizing you up just like you're sizing them up. And if you get too caught up in trying to size the individual up, try to size up the individual, you get to a point where there's really no energy left. Each person is trying to out-talk the other person. Oftentimes you have a witness, the witness will wind up questioning you. You find yourself giving all the answers and you get nothing out of the witness. It happens. It truly happens. For the person, the prosecution witness, his or herself, I'll say this much. Because someone confronts you or is before you regarding, let's say, a criminal matter, and you are a prosecution witness, you're a witness for the prosecution, but because the prosecution has seen something that he or she feels will be credible to their case against the defendant. However, that still does not say that the defendant is either guilty or innocent. It just means that you have something that may be helpful in the case that the prosecution will be preparing against the defendant. By you talking to a private investigator, that in and of itself does not change the reality or the reality of whether or not the person is innocent or guilty. It is additional information that's made available to the other side to help create a more balanced inquiry, which hopefully will result in justice. That being the whole concept between the scales sliding up and down, representing the essence of justice. And so I say to you, if you are a prosecution witness, that tells me you want to be helpful. That help can be, it can be disseminated in a sense. First of all, there's no law that prevents you from talking to the other side. The district attorney or assistant district attorney, ADA as they're referred to oftentimes, can suggest to you that it may not, and I emphasize the word may not be a useful thing to talk to the other side. You may hear something along those lines, but cannot specifically say you are not, or I forbid you to speak with the defendant's attorney or any representatives. And so keep that in mind. You'll never know. You'll never know. Something could happen to you. And you have a private investigator reach out to speak with one of the prosecutor's witnesses. And they simply refuse to say anything. And they may have very critical information that for whatever reason, they may not have even spoken to the district attorney about. These things happen. How many times have we sat back and looked at TV and we find someone's been locked up for, 20 years, 25 years or so because of some deficiency in the system, be it the police, the prosecutor, be it a witness. It goes on. And that's why these things are critical, and that's why you can actually do it. That's why a private investigator, I'm getting tongue-tied here. That's why a private investigator can speak with a prosecution witness. You just have to make sure you do it the right way. And for heaven's sakes, document it for your own safety. You're a great audience. I can see you guys really hanging in on this, and that's appreciated. And of course, it's very meaningful. If you don't pay attention, what can you possibly learn? How much can you possibly remember without getting into it, paying attention? So I appreciate you hanging in there. I like to say to you, dream with purpose, act with intent, subscribe. Subscribe to the channel, press the notification bell, leave some comments. I enjoy speaking with you. And until next time, I say to you once again, dream with purpose, act with intent.